Yes, good afternoon, my beloved students. I hope everybody is doing fine. So, as is customary, let me just give like 5 minutes of grace. So I'll come back to you at exactly 5 minutes after 2. Okay? So good afternoon, ladies and gentlemen. I guess we can start the class now. I've also enabled my live YouTube channel video. So your colleagues, if they are not able to join us after it reaches the 300 limit capacity, can follow us on my YouTube channel. All right, so we are good to go. I hope you guys are fine. So the message I sent across to you was that you should listen to the lecture on insanity, to the lecture on non-insane delusion, and to the lecture on minority. And like I used to say to encourage students, I have been teaching criminal law for over 28 years. I've written a textbook on criminal law. Anytime I have a criminal law class, I prepare as if I've never taught the class before. Even before this class, I've had to listen to the lectures again myself. So I'm saying that to encourage you that you also need to do your own bit in the academic journey. Your bit is to engage yourself actively, to invest time, energy, and resources to study. to prepare yourself. Now, you are receiving lectures from home. That is not an opportunity to just be lazing about. It's an opportunity to listen to your lectures, find time to, begin to read and begin to prepare for exam. Because by the time we come back in January now, by the time we have like 4 more weeks or 5 more weeks of lecture, exam timetable has come out. So I want to encourage you that, criminal law is not difficult, but you have to devote time. You have to devote time to study. You have to devote time to study, to learn. Whatever you learn now, nobody can take it away from you. Some of the things we use now as residual knowledge are things we have learned while we were students. And the only reason why we have them as residual knowledge now is because we are taking time to acquire the knowledge when we were young. As a lawyer, there are many things you would need to respond to on the spur of the moment, that it is your residual knowledge and depth of the knowledge of the law you acquire as an undergraduate that will provide you the basis and the platform. Recently I'm engaged in providing expert legal advice in an ongoing arbitration in the United Kingdom. I've been consulted to offer expert legal advice on Nigerian law on plea bargaining. As you may know, I've also written a book on plea bargaining in Nigeria. So without the in-depth knowledge, you will not be able to do these things. So I'm encouraging you. You guys, you generally belong to the younger generation. Now we have more younger students in our classes. So you don't have anything disturbing you. So you must take time to invest time, energy, and resources in knowing the law. It is in knowledge of the law that you know. Now in that arbitration that I was talking about, I've been thanking God that I studied international law in my undergraduate days. For us in Uniben then, it was a compulsory because I went to Uniben for my first degree. In Unilag now, it's an elective. Without the knowledge of international law that I had acquired as an undergraduate, there is an aspect of this work that I'm doing as an expert legal advisor on Nigerian law that I will not be able to do because there were issues of international law, issues relating to the law of the sea, to exclusive economic zone that I've had to grapple with. I had to do some additional research, but those additional research were assisted by the fact that I had some foundational knowledge of those principles. So, the same way you are studying criminal law is very important. And criminal law practice in Nigeria has grown in the last since 2005. A lot of more lawyers are now engaged in criminal law practice. So I encourage you, it's a core course, particularly all the core courses. Invest energy, time, and resources in studying them. Don't just study because you want to read for exam and pass exam. No. Study because you want to know the law. So that knowledge, if it is deep now, can abide with you through your legal practice years. And whenever you have any issue comes up in that area, it's easy for you to do research because you have laid a foundation in that area. So I don't want to spend more time on that, but I just feel that, we need to, once in a while, charge our students to know that it's an opportunity that you should count yourself privileged, that you are studying law at the Faculty of Law, University of Lagos. It's a privilege. It's not that we are boasting. It is a privilege. And that privilege, make the best use of it. So that's just an advice. So back to our business for the day. I ask you to listen to the video again on insanity, on non-insane delusion, and the defense of minority. So those are the 3 topics that we are going to engage in today in terms of conversation, questions, and answers. So for the next 30 minutes, so the time now is 2:12, that should take us to around 2:45. I'm going to allow you to ask questions on the defense of insanity. Then after that, we'll devote another 15 minutes to questions on non-insane delusion, and maybe about 10 minutes to questions on the defense of minority. So If you have questions on the defense of insanity, raise up your hand. I will enable you to unmute, and then you can ask your question. Thank you very much. So I'm going to put up my video now because the video normally adds to the weight of the bandwidth. So please don't put on your video. I only try to do this at the beginning so that at least we can have some level of contact. Okay. So Tayo A. Adekunle, unmute.
Good afternoon, sir.
Good afternoon. How are you doing?
Thank you. Very well, sir. Thank you for all you do. So I understand that everybody enjoys a presumption of sanity under Section 27 of the Code.
Yeah.
And that the defense is in Section 28. So I want to ask a defendant who is pleading that defense, is it compulsory that it must also lead maybe medical evidence from, say, a neurologist or a psychiatrist before the defense can avail him? Thank you, sir.
Thank you very much. That's a very good question. Now, ordinarily in criminal proceedings, it is the prosecution that bears the burden of proving the guilt of the offender beyond reasonable doubt. But the law allows a situation in which a defendant has the burden of introducing evidence. Okay, so in this instance, the defendant has a burden of introducing evidence to establish his insanity. Now, ordinarily, the commonest way of leading evidence to establish that is to adduce medical evidence, because in most cases, insanity can be proven by medical evidence. But that does not mean that medical evidence is the only means of proving insanity. Other pieces of evidence may also exist that others may testify to, which may suggest that the defendant is suffering from mental disease or natural mental infirmity. For instance, if there are evidences of relations of abnormal behavior, over a period of time, of serious abnormal behavior, showing some form of mental defectiveness, those kinds of evidence and the circumstances, can also assist the court to come to the conclusion that, yes, this guy must be suffering from some form of mental disease or natural mental infirmity to such an extent as to lose any of the three capacities under the provisions of the first paragraph of Section 28. So medical evidence is usually important, but other forms of evidence can also assist the court to prove that the defendant is insane, legally as required by law. All right, so let me. Unwoba Samuel Stephen. Okay, maybe I'm going to note. Maybe I should be noting students who ask questions regularly in my criminal law class, because I'll find a gift to give them. So just let me get my pen, because I can see some names that I've been recalling in my class. Let me get my pen. So if your name constitutes regularly, the student is very active. I can always find a gift for you. I mean, I can give you a copy of my book on the overview of plea bargain. I can even give you a copy of my book on criminal law, maybe at the end of the semester, if I find that you don't have a copy. So somebody who has always been asking questions that I've noted now, writing your name down, is Unwoba Samuel. Unwoba Samuel Stephen. I'm going to edit now. So people who ask questions regularly may get a gift. So you can unmute Unwoba.
Okay, sir. Good afternoon, sir.
How are you doing, my brother?
I'm very fine, sir. Okay, I have about 2 or 3 questions.
Yeah, so take them one by one, and let me take them one by one, because I usually like to take questions.
Yeah. So the first one is just a general question on insanity. I wanted to know what extent would a plea of self-defense avail a defendant claimant. So in this scenario, let's say that a person who is insane trying to cause a grievous harm or even apprehension of death to a normal person. And let's say that this person, in that scenario, perceiving that although he knows that this person is insane, this person has some kind of mental direction, decides to, do some grievous harm, or maybe in that regards, this same person or this mad person or this madman dies. So can that person, successfully plea or kind of plead a self-defense? So with that, I wanted to know, sir.
Okay, so let's take it one by one. Now, the fact that somebody is insane and is taking action which creates a reasonable apprehension of death or grievous bodily harm in somebody who is raising his plea of self-defense, it is not a disentitling factor. What the law requires is that the person attacking you creates a reasonable apprehension of death or grievous bodily harm by the kind of attack or by the kind of threat or violence that he wants to inflict on you. Now, the fact that he's insane is not an issue. Otherwise, is it because he's insane, you not allow him to kill you when the law gives you? So that doesn't disentitle the claimant from relying on a plea of self-defense. Of course, the only thing is that if he has if knowing that the assailant is insane and he has an opportunity of leaving the scene and running away rather than exercising his right to self-defense, then that may create some problems for him. But ordinarily, the fact that the person is insane will not disentitle the claimant from, because what the law is interested in is there a reasonable apprehension of death or grievous bodily harm, which is precipitated by the acts of the assailant, and that is what will entitle the victim to use proportionate force in response, even though that response may unfortunately result in death. Go on to your second question.
Okay, thank you. So my second question touches upon the third leg with the loss of capacity, of an insane person. Now, when I was going through your textbook, I went through this case of the Indian case of Nasruddin against the king. I wanted to know why the appellate court, made their ruling in that regards, whereby the appellate court ruled that even if Nasruddin, was aware of the criminality of his act, however, he did not know that it was wrong, and therefore they entitled, that particular Nasruddin to the defense of insanity. Though the fact goes by saying that Nasruddin, killed his child on the belief that he has been directed to do so by his god, or maybe the god he was worshiping. So I wanted to know why the appellate court, reached that kind of conclusion, though he knew, but they still granted him, the plea of insanity, because I didn't see any element of insanity.
What you need to understand is that this has to do with loss of capacity. The case did not devolve on the issue of whether he is suffering from any loss of disability. The issue relates to loss of capacity. And under the Indian provision is similar to what we have in the penal code. The penal code also says that the third capacity is that the person must know that he's doing what is either wrong or contrary to law. So if he knows that what he's doing is contrary to law, but he believes that it is not wrong for him to do it, that would have availed him a defense. Now, their third leg of capacity, loss of capacity, is different from what we have under the criminal code. The criminal code merely says that he should know that he ought not to do the act or make the omission. But the approach adopted under the Indian penal code and under the criminal code is a bit different. That is the one talking about that he must know that the thing is either wrong or contrary to law. So it was that interpretation that led the court to take the decision that was taken in that case.
Okay,
although
thank
even
you.
with respect to the third leg of the provision under the criminal code, Okonkwo and Nash has suggested that the provision should be required to construed to require that the offender knows that his act is wrong or contrary to law. So they also seem to support that interpretation and even argue that the criminal code provision, even though it's not worded directly like that, should be given that kind of interpretation. Because the important thing is that, look, mental disease has different effects on different defendants. But what is important is we want to be sure that he has lost capacity. Either he feels that because of the mental disease, he believes that what he's doing is not wrong. He may believe that the thing is contrary to law, that the law says you should not kill. But maybe he now believes because of insanity that it is not wrong for him otherwise than to kill, or to believe that for instance, if he believes that because of his insanity, he believes that his religion allows him to kill somebody, that means that he does not believe that the thing is wrong. So in any case, what is important is that he is not in control of himself. And that is lack of being in control of himself is induced by the mental disease. So he's not a normal functioning human being will not believe that it is right to kill somebody. Even if he believes that the law frowns at killing somebody. Even if he believes that the law frowns at killing somebody, but he still believes that it is right for him to kill somebody because of his insanity. He still does not have capacity. Okay. All right.
Okay, I still have a question.
Oh, okay. Yes, you said you have 3 questions. Please go
on. So my third question is with respect to the case you cited, and the case of Arad Window. I know the bill of contention there was, what's the distinction between what is wrong and what is contrary to law? So I don't know if you can, help me clarify that, because that also, the Australian court in the case of Stapleton against R, vehemently rejected the position of, the position made in Magnotta rule, with respect to what is wrong and also to what is, contrary to the law. So I'm kind of confused there. If you can
well, you see,
well,
you see, the point is that is the way it has been interpreted in Australia. I mean, you can even see it's not worded that way, but he believes that the court should be. What is important, like I have said, what is important, like I've said, is for the court to come to a determination of what is the effect of the insanity. If the effect of the insanity is to make the offender to lose his capacity to appreciate what he is doing, that appreciation may come in terms of the wrongfulness of his conduct. He does not appreciate that what he's doing is wrongful. Meanwhile, all of us who are saying we know that what he's doing is wrongful. Or even if he appreciates that what he's doing is wrongful, he does not appreciate, because of his insanity, that what he's doing is contrary to law. So both ways, the important thing is that he does not, understand the nature and the quality of his act. He does not understand the nature and the quality of his act. And if he does not understand the nature and the quality of his act, then why do we, want to hold him responsible for the, why do we not allow the defense of insanity to avail it? Remember that under the Magnotta rule says he does not know the nature and the quality of his act. For me, that is even though the phraseology is different, I believe that can be interpreted also the same way the penal code is worded. Does not know that what he's doing is wrong or contrary to law. Because if you understand the nature and the quality of his act, you understand what his act entails. definitely will include understanding whether the thing is wrong or whether the thing is prohibited by law. You know, so I think the emphasis should not really be on the phraseology, but the emphasis should be on the impact of the acclaimed mental disease, and to see whether it has sufficiently, you know, affected the capacity of the offender to really know and have an understanding of his conduct. If we were able to come to any point that it does not have that, then I believe the defense of insanity should avail.
Yeah,
All
thank you,
right.
sir.
Thank you. Elizabeth Praise Ajama. You're allowed to unmute.
Okay, sir. Good afternoon, sir.
How are you doing?
I'm very fine, sir. Thank you. So I have two questions, but the first one is under non-insane delusion.
No, well, you can ask. Go ahead. You can ask non-insane delusion. It's still connected with insanity. Go ahead.
Yeah. So my question is, these personality disorders, psychopaths and sociopaths, because they can be somehow destructive at times. And since it's just a personality disorder, so I want to ask, are they under non-insane delusions? Can they be brought up as a defense under it as
Now,
well?
you see, you will see that if you listen to that video carefully, I took some time to explain the difference of non-insane delusion. Now, when you talk about delusion is a state where somebody is, you know, perceiving facts which are not real. Okay? Somebody is perceiving facts which are not real. For instance, I mean, I don't know where you are now receiving your lecture. You know, maybe you're at home, or maybe you are in a place with some of your friends. Now, imagine one of your friends imagining and telling you that I can see a lion coming in, a lion coming into the door. See the door, a lion is coming to come and attack us. I mean, you'll be wondering, is this person, are you for real? Where is the lion? We're in the room now, or we're in the lecture room now. Where are you seeing the lion? The person is perceiving something that is not real. Okay? Is perceiving something that is not real. And a person who is perceiving something that is not real, that can only be a symbol of mental defectiveness or mental disturbance. So if somebody is perceiving something that is not real, and that is perception, is a product of mental disease or natural mental infirmity. Usually it has to be. I mean, a normal person functioning normally cannot just sit down as you are sitting down wherever you are now and imagine that a lion is jumping through the window coming to attack him and is running away. Hey, see lion, let's run. You know? So delusion itself is almost a sign or a symbol of either mental disease or natural mental infirmity. And that's why I took time to explain in that video that if it is insane delusion, if somebody is deluded, and that is delusion is a product of mental disease, then the defense of insanity should govern the circumstance. The defense of insanity should govern the circumstance. And in most cases, delusion will be a product of mental disease or natural mental infirmity. Because if you're not, so that second paragraph of section 28 can only be dealing with non-insane delusion. In other words, delusion that is not produced by mental disease or natural mental infirmity. But like I've said, most cases of delusion will be traceable to mental disease or natural mental infirmity. And if it is, the defense of insanity already covers the situation. So that's why, you know, when we were reviewing the criminal law in Lagos, we recommended that the provision on delusion should be removed. And that's why the provision has been removed from the new provision on the equivalent of the offense of insanity, you know, under the criminal law of Lagos, and even also under the criminal law of Edo State. So that defense of delusion in the second paragraph is completely out of place, you know. So I don't know whether that answers your question, or whether there's still a way you want me to, there's still an issue you want me to address. You know, that was why it took a lot of time to, you know, carefully, explain that point. And I also noted that in the Supreme Court case of Udofia versus the state, Obaseki JSC respectfully, wrongfully characterized the second paragraph of section 22 as insane delusion. It cannot be insane delusion. If it is insane delusion, then it is insanity. If it is mental disease, if the delusion is perceiving fact that does not exist, is living in a world, in an unreal world, if that is a product of mental disease or natural mental infirmity, then it is the defense of insanity that should govern it, rendering the second paragraph completely, you know, irrelevant. Completely irrelevant. Yes, so I don't know if that answers your question. Igbinosa or Sanyeme Joe. I've enabled you to unmute. So we are still looking at the defense of insanity, and the last student brought in non-insane delusion. Yes, go ahead.
Okay, good afternoon, sir.
How are you doing?
I'm fine, thank you, sir.
Great.
So my first question, yeah, is on the second leg of the definition of insanity by the Criminal Code,
Okay.
which describes disability as a natural mental disorder. So you said that it does not include something that is done by the as something that is as a result of the conduct of the defendant, and also a disease of the mind. So does that mean that it is something like probably the person was born with or something? Because you then referred us to what the court said of it being something that the person has when it's probably before the age of 18. So is that the only situation that natural mental disorder covers, or are there other circumstances?
Well, you see, that is part of the problem. You know, part of the problem with the phraseology of the disability component of the defense of insanity under the Criminal Code is the use of the phrase mental disease or natural mental infirmity. These are words that, you know, don't seem to have a clear defined meaning. And that was why, you know, when the criminal law in Lagos was, you know, being done, we recommended, you know, and we changed the name of the offense from insanity to, you know, what did we change it to now? You know, we changed it to
mental disorder, sir.
Yes, we changed it to mental disorder, because you see, there are different forms of mental disorder. There are different forms. So you cannot, it's better to use the generic term mental disorder. So whenever anybody is now claiming any mental disorder or mental disability, then the medical people that are the ones that usually, you know, relate with all these different types of mental disorder, schizophrenia, psychosis, depression, and so on and so forth, can then give evidence as to the nature of the sickness. And then once they're able to establish that this is a sickness that can affect mental capacity, the question now will be that is not now a question for the medical expert. That's now a question for the court to now determine whether that mental disorder has sufficiently impaired the offender's capacities, you know, in either of the three circumstances. So, you know, the phraseology under the under the criminal code is a bit problematic. And that's why even the one adopted, the phraseology for the disability under the penal code, section 51, is on soundness of mind. That's even very general. On soundness of mind. What can make the mind not to be sound, not to function properly? You know? So, but some attempts were made to, you know, provide a clarification as to what constitutes natural mental infirmity. You know, and the court said that it's a defect in mental power. A defect in mental power. In other words, your mental capability has a defect. Neither produced by its own default. In other words, it is not produced by instance with the offender consuming alcohol. Because if you consume alcohol, of course, that is intoxication. You know, we know the rules relating to intoxication. That intoxication can produce a defect in mental power. So you cannot rely on alcohol, for instance, because that is produced by your own default. And it cannot be a disease of the mind, because the disease of the mind is another, is another ground on its own. And then the court then, went on to look at the meaning of mental defect, in the English Mental Deficiency Act, to mean a condition of arrested or incomplete development of the mind existing before. Yes, this can produce it, but there could also be some other natural causes that may produce it. This doesn't necessarily rule out other natural causes, because it talks of natural mental infirmity, something that is genetical. Maybe there's a genetical composition, in the makeup of the individual that produce mental defectiveness that does not enable him to function the way every normal human being will be able to function. But you see, you can see how problematic it is. But the medical people to whom we often resort to when, defendants are raising defense of insanity, it's better to use a term that they will be familiar with, which is what was done in Lagos, to use the word mental disorder. Okay.
Okay, sir. Thank you, sir. Sir, I have a further question, sir.
Yes, please go ahead.
Okay, so I also want to make reference to something you said, that natural mental infirmity doesn't cover situations where your insanity is as a result of your own conduct. So what
yes,
of a situation?
I gave an example of that. Yes.
For drinking alcohol. Yes, I got
yes.
that. So also, for example, an instance where someone actually smokes, someone is a smoker, and as a result of the smoking, the person got insane and in that state committed a crime. Will the defense of insanity still avail the person?
Well, you see, that will not be a case of natural mental infirmity. That will not be natural mental infirmity, but that could qualify as a mental disease. In fact, I was amazed. I was listening to one health talk on the radio one day, and the doctor said, and that's why I'm urging you people are young people, don't experiment with any form of drugs. The doctor was saying that just a sniff of Indian hemp, depending on your body composition, can make a person to be completely mad, irreversibly mad. Just one sniff at Indian hemp. So if somebody is in the habit of taking Indian hemp, and the reason they give for that is that everybody's body composition is different. Some people, they can smoke Indian hemp for as long as they want. The thing will not affect their mental functioning. But some people, just one sniff, and then the thing will affect the person permanently. The person cannot be able to recover his mental, functioning. But it is possible for somebody who has been smoking Indian hemp. It may get to a point that the Indian hemp may permanently affect him and cause a mental disease. Yes, so that may equate to mental disease, because that disease, although the disease was caused by his own action. That's not natural mental infirmity. Natural refers to something that, is organic, that is not a product of any external stimuli. Even alcohol, if it gets to a state, somebody who consumes alcohol, the thing can permanently affect the brain to the extent that the person develops a mental disease. So if it gets to that point, the person can rely on the defense of insanity. Because at that point, he's now suffering from a disease. The focus is not on what triggers it. The question is at that point, because at that point, it is now a disease. He cannot even go back to the normal functioning again. So those are the clarifications. Yes?
Okay, thank you, sir. Sir, please, I'm sorry, sir. Please, I'm sorry. I just want to ask one last question. Or two, sir. Sir, please, for strict liability offenses, since they do not require the element of mens rea before conviction can be made, does that mean that an insane person can be convicted for an offense that he commits?
Well, ordinarily, for strict liability offenses, the law does not require a mental element. But once a person is insane, he cannot be held liable for any offense, whether strict liability or non-strict liability. He cannot. Because what the insanity means is that he did not even know that he did what he had done. But the person who is sane knew what he did, even though he did not do it with a faulty mental element. Why the law is holding him responsible is because of what he has done. It's because of his acts. Because that act is punished for some other greater societal interest, maybe for the sake of public health or for the sake of protecting others. The law just criminalizes it that you must not do this. Once you do it, it's an offense. But for the same person, once there is medical evidence to prove that he's suffering from mental disease or natural mental infirmity, and that has, resulted in a loss of capacity, it cannot be any offense, whether or whatever offense it is. All right, thank you.
Thank you, sir. Sir, please, can I ask one last question? Sir, I'm so sorry, sir.
Go ahead and ask.
Okay, thank you, sir. So my question is as regards what you thought about relevant time. You said that the relevant time that the court will consider is insanity at the time of the commission of the offense. So,
Yes.
and you also stated in your explanation that some insane people actually have lucid moments. So if during a lucid moment, a person commits an offense, then the person cannot plead the defense of insanity. So I want to ask, so what kind of verdict will the court give for such a person? Because regardless of whether or not
found guilty, if there is evidence to show that he has lucid intervals and he committed the offense during his lucid interval, then he will be punished for the offense.
But sir,
you will be punished for the offense.
Okay, but sir, I feel like regardless of the fact does not change that he's still mad. So it doesn't.
No, you see,
he's still.
Hold on. Let me explain it. Let me explain it. You see, there are degrees of insanity. There are degrees of mental disease and mental defectiveness. For some, it is permanent. They can't even do anything normal again. But for some, it comes and goes. And you see him behaving normally, talking sensibly, engaging in logical reasoning, logical conversation. And then suddenly, something will just overcome him. And then you know that, the lucid moment is gone. So if he commits an offense during the lucid moment, there are evidences that will show that he commits the offense in a lucid moment. For instance, if during his lucid moment that he has an enemy, everybody knows that that person is his enemy, and they've had conflicts on different occasions, particularly when everybody knows he's lucid. So he now kills the person during a lucid moment, and quickly he now tries to clean up the place, tries to dispose of the evidence that would have implicated him because he knew what he did when he killed the person. For instance, if he quickly you know, if he was found, maybe after stabbing the person, some of the person's blood splashed on his dress, you know, and then so immediately he went home, got home, packed the dress into something, and went and the murder weapon, and went and threw it in a far away waste dump. And he was arrested on his way back home from the waste dump. And unknown to him, somebody saw him when he was attacking the victim. Now, the evidence that he tried, the circumstances that he tried to hide evidence, and the fact that there is evidence also that at his lucid intervals, he had a long-standing quarrel with this particular person. Everybody knows the two of them to be sworn enemies. And the police now arrested him on his way back from the waste dump. Unknown to him, somebody saw him. And when the police had information that he was the one that committed the offense, they saw him coming from the waste dump, and somehow they went back to the waste dump, and they were able to trace his cloth and the murder weapon. And of course, you know, his fingerprint will be on the knife. And everybody knows that this is his cloth. And the victim's blood splashed on the cloth. That is evidence that he was lucid when he committed the offense, because he was trying to hide evidence. So
okay, sir.
It depends on the degree of insanity. Some insanities is permanent. The person does not reason again, does not do anything normal again. It's just like that. But some, they have lucid interval. So it depends on the evidence that is available. Yes. So let me go to others.
Okay, thank you, sir.
Okay, hold on. When we finish, so that it does not appear as if you are the one that mobilize all the questions. So just hang on. When we finish the testing room, then I will allow you.
Okay,
so
thank
mute
you very
yourself
much.
back. Mute yourself back. I'm trying to unmute Daniel Joy. Haven't you spoken before?
Daniel no, Joy. Sir, I've not spoken before, sir.
Okay. So go ahead and
yes,
unmute.
Sir. Thank you, sir. So my question is this. Someone that successfully pleads insanity or mental disorder, does the person automatically get put in a let's say psychiatric institution or something?
Yes. Okay. Now, when a person successfully raises the plea of insanity, and there is evidence to show that yes, at the time he committed the offense, he was suffering from mental disease or natural mental infirmity, and he was able, the evidence established loss of any of either of the three capacities, the court will enter a verdict of not guilty by reason of insanity. Now, when the court enters that verdict, now this man, he has killed somebody and is insane. So the court will commit him to be detained in the word asylum is no longer used these days because asylum is said to be pejorative. The court will order that he should be detained at the pleasure of the governor. In some other countries, they have medical facilities that is like a prison where they detain them. Now, when they detain them, they monitor them. Like I said, you know, some of these mental diseases, some of them are curable. But if the one for this particular offender is not curable, then he will continue to be detained for the rest of his life. But periodically, they do a medical review and try to see whether if it is a kind of mental disease that is curable. They do some kind of medical evaluation to find out if he had recovered. Then if he had recovered, he would then be released because he was not found guilty initially by reason of insanity. So he may be released, but if upon every periodic review, the evidence still shows that he's still suffering from this mental disease, then he continues to be a threat to the society and he will live for the rest of his life in that medical facility.
Okay, sir. Thank you, sir.
Omole Emmanuel, you can unmute.
Good afternoon, sir.
How are you doing?
I wanted to ask, I have two questions. So I want to ask one short question before I go to my second question.
Go ahead.
Yes. The plea of non-insane delusion, is it a complete or partial defense? to a crime
Well,
in Nigeria?
If we assume that somebody is able to succeed on a plea of non-insane delusion, then it completely exculpates. But again, just like the defense of insanity, the question will be, should the court release him to the society? For me, the court will be minded to make an order to have him medically examined to find out whether, if he's released to the society, will not be a threat to the society, because if he's always imagining that a lion is coming and he sees a normal human being approaching him as a lion and he killed one, so he was able to go to court, prove his case of non-insane delusion for one reason or the other, the defense succeeds, and the court releases him, and he's still suffering from that his illusion of grandiose. He sees another person, he thinks the person is an armed robber pointing a gun at him. Meanwhile, this is an innocent person who was just trying to greet him. Hello, how are you? Please, can you direct me to, I'm going to Yaba. Can you direct me on the way to Yaba? And he thinks that he's seeing an armed robber with a gun trying to shoot him. And he brings out a cutlass and he cuts that one again. So for me, even assuming that somebody is able to succeed on defense of non-insane delusion, he should be subjected to medical examination and review to determine whether his release to the society will be safe for the rest of us.
All right.
Second one.
All right, sir. So that takes me to my second question. So I have a scenario. So let's say a Nigerian who got wealthy.
In Nigeria, who did what?
And was there for like a few years. He was making money. He traveled to America. He got wealthy and he traveled to America. And he was making money for years, like 5 years. Then suddenly things turn around, and then they deported him back to his village in Nigeria. So let's say one night, as he was after his deportation, he was in his village, and he had a nightmare that the people that did spiritual things to him, that made them deport him back to Nigeria, they're under a tree in the market square the next day, and then he wakes up and he becomes troubled, and then he thinks.
Sorry, you are breaking. We cannot hear you again. Oh.
Then he took a gun under a tree, and there were like around 50 people there, all of them women, and then he shoots all of them.
So, and he thinks they're the one. He thinks they're the one troubling him, Abi.
Yes, based on his nightmare.
So he thinks that they are what? He thinks that they are what?
They are witches that did them charm on him to make them deport him back to Nigeria.
Oh, okay. Like that, those are the people that charmed him.
Yes, to make them deport him back to Nigeria.
Let's assume, okay, I think I have enough facts to address the issue. Let's assume that qualifies as non-insane delusion. Now the question is, if some people charmed you, and that charming made them to deport you from America, and that's what you believe in your grandiose world, does that entitle you to kill them? Does that entitle you to rely on self-defense? Or what defense does that entitle you to rely on? Remember, the second paragraph, if you believe something that does not exist, your liability will be based on whether what you believe is true or real. So let's even assume that, yes, that is the truth. The people that you thought were under the tree, they had a charm, and they charmed you with bad luck. And that bad luck made the U.S. Department of State to deport you from America to Obodo, Nigeria. And you still, in your make-believe world, you believe that these are the people that are responsible. The question will be under the second paragraph. It says your liability will be assessed based on the reality of your belief. So if it is true that they are the one that charmed you, what does that entitle you to do? Does that entitle you to take a gun and kill them? No, the defense will fail, and you'll be sentenced to death. The person will be sentenced to death. That's it. That's the problem. That's the problem with that defense.
Sure. I guess expansion.
That's the problem with that defense. Somebody who believes that kind of belief, is that the person a normal human being? It's not a normal human being now. So it should be a case of insane delusion. I mean, it should be yes, it should be a case of insane delusion, because anybody who is deluded is, I can say, almost 100% is suffering from mental disease. So why do you believe that as you are sitting down, wherever you are now, that the lion is coming inside to come and kill? Where is the lion coming from? Is it from Yankari Game Reserve, or is it from northern Nigeria? Or where is the lion coming from? We don't have lion in this part of Nigeria. So where would the lion come from? So the person is, there's something wrong upstairs with the person. So
Thanks, sir.
defense of insanity. Yeah. Second one.
Yeah, my final. Yeah. I have one final question. So I wanted to ask about the. Okay, good. I wanted to ask you about the procedural rules of pleading in the plea of non-necessary decision, because anybody can kill anyone.
Sorry, I didn't hear that.
It was
I didn't hear that.
Okay. Can you hear me now, sir?
Yes.
I want to ask about the procedural rules of pleading the plea of non-necessary delusion. So anybody can go ahead and kill another person and say that it was under him.
That's what we are saying now. That's why it was said in that lecture that ordinarily you would require some medical evidence. And what would the medical evidence prove, if not insanity? Do you understand? The medical evidence will prove mental defectiveness. And if it proves mental defectiveness, yes, then you are insane. Then the rule of insanity should govern. So that even if you succeed on that, we will lock you up. We'll lock up the person. That's the problem, that is exactly the point. All right. Great.
All right, sir. Thank you, sir.
You can unmute. Great.
Thank you, sir.
After these last 4 people that are holding on, then we'll move on to minority. Yes, Grace, unmute.
Thank you, sir. Good afternoon, sir.
How are you doing, Grace?
I'm fine, thank you, sir. So, my first question has to do with lucid intervals in the plea of insanity. So we have established there are different types of mental disabilities, and there are some that maybe in between a person might have lucid intervals. So what would happen if, for example, whilst committing a crime, somebody has a lucid interval? Like maybe somebody that is insane has a lucid interval. Will the fact that probably at some point in the commission of the crime he was insane negate all his liability? Or would the fact that he had a lucid interval whilst committing the crime negates the defense of insanity?
Yes, if it can be proved. You see, it may be difficult to establish. If there is general evidence that this guy behaves in such a way as to show that he's suffering from either mental disease, it may be difficult to prove the lucid interval, because you require evidence to prove that the prosecution will have to prove that the thing occurred during his lucid interval, and that may be difficult to prove, but it's not impossible. But if it is established that he committed the offense during his lucid interval, the defense of insanity will fail.
Okay.
It will fail. Okay, so Adewale Koinsola.
Oh, sorry, sir. I have a second question.
Okay, quickly.
Sorry. So, my question has to do with this belief that okay, even though the person might know that it is wrong, but they might have had a belief that because of their insanity. So, I mean that some people might know that okay, what they are doing is not is against the law. But because they were laboring on some mental disability, they did not believe that what they did was actually wrong. So I find that quite problematic, because honestly, there are some people that just believe that they are above the law and they will do some things, right? And when they are
those people that are above the law, they can think that they are above the law. We hold them responsible, but what we are focusing on here is people that are suffering from mental disease and natural mental infirmity, who because of that did something that they do not believe is wrong. That's what we are talking about. We're not talking about people who believe they are above the law generally.
Okay, sir.
We're not talking about people like that. Yes.
All right. Thank you,
sir. Oyin Damola Sophiat.
Hi, good afternoon, sir.
How are you doing?
I have 2 questions. like real life scenarios. I just want to ask what kind of defenses will be available for them.
No, it has to relate to the defense we are doing. It's not a general question.
Yes.
So it's not a general question as to what kind of
Yes,
defense.
it's not a general question.
Okay, go ahead.
The first one is on non-insane delusion.
Okay.
So I've heard that in a church whereby there's a pastor goes into trance and he goes to meet one of the congregation, one of the members, and pushed her down and said, "You evil spirit, come out." While pushing the girl down, she went down and hit her head and she died. Then immediately the pastor came back into to his senses and was like, "Oh, what happened? Who pushed her?" So there's evidence that he didn't know what happened, and there's proof that he's a sane person. But at that particular point in time, something took over his body and he pushed the girl and she fell and died. What kind of defense would you say would be for that pastor? And if there are no defenses, what would the court decide on?
That one is a bit difficult though. So he was the spirit suddenly entered into him, and that spirit made him to push somebody. He pushed a lady, Abby.
Yes.
And the lady fell down and died.
Yes.
And there is no evidence that the pastor is suffering from any mental disease or natural mental infirmity.
None whatsoever, sir.
Okay. Now, even this is not a case of delusion, because he knew that he touched the lady.
No, he did not know he touched the lady. When he came back to his senses, was like, "What happened? Who pushed her? Why is she on the floor?"
Well, delusion relates to a perception, having a false perception of reality. And in this instance, he claims not to know that he was the one that pushed her. So I'm not quite sure how that will. I can't see through in my mind that constitutes delusion. But
okay, sir.
Hold on. Okay. I'm trying to look at now. He pushed the lady, and the lady fell down and died.
Yes.
Another push will not make somebody to fall down and die. It
she
could probably be a very violent.
After she hit her head after the push.
So as far as he will probably be prosecuted for manslaughter. Okay. Because pushing somebody down in a violent manner is something dangerous, and it does not have a lawful basis for doing so. You can't read an intention to kill from that kind of scenario. But
mind you, sir, while he was in trance, he said, "You evil spirit, come out of her," and pushed her.
Yeah. So except, well, it will be interesting, except if that can be taken to mean he was deluded that the woman possessed an evil spirit. Even if it was yes, good. Let's even assume that we agree that was delusion.
Okay.
The question would be, what would be his liability if what he believed was true? If it was true that the woman possessed evil spirit and he pushed the woman down, his liability for pushing the woman down, the fact that the woman he believed that the woman is possessed by evil spirit, does that justify him in pushing the woman violently in such a manner? Hold on. In pushing the woman violently in such a manner that the woman fell down and died? The answer is no. So even assuming that the woman is possessed of evil spirit as he believed, because the second paragraph of section 28 says that what you believe, let's even assume that what you believe is the truth. What is your liability? So yes, he believed that the woman is possessed of evil spirit. Yes, let's assume the woman is possessed of evil spirit. Does that justify pushing the woman in a violent manner?
What if she consented to it, sir?
No. From what you are saying, there's no evidence of consent now. The woman was not standing. The woman was not standing on her own now. The fact that somebody is in a church or in a place where they are praying prayer, does that mean that he consent to him coming to push her down? It would have been different. Hold on. It would have been different if what you said was that he laid his hands on her, and then she responded by tumbling over.
Oh, okay.
The laying of hand on her is not a violent conduct. Do you understand?
Yes.
And because it's not a violent conduct, if the woman reacts violently, you cannot say that he's responsible for that. But in this instance, he will be liable for manslaughter. Because even assuming that the woman has evil spirit, yes, he believes that the woman has evil spirit. I say, evil spirit, come out.
Come out.
And the evil spirit refused to come out. And the woman, because of his push, the woman fell down, broke her head, and died. That's manslaughter. Because by pushing somebody violently, there's a risk that that may endanger human life. And he has no lawful basis for pushing the woman. So that renders him liable.
Manslaughter.
Okay.
My second question.
Okay, quickly.
I don't know where this falls under, but a guy has a friend that introduced a new drug to him. It's not in there. It's like cocaine, something like that, but it's hard drugs. And he took it, saying, this one, sorry for using Yoruba, it cannot affect me, something like that. Then when he used it, he got into trance and took a cutlass and started pushing everybody with cutlass. People were like, he won't do anything. But in that situation, he killed 3 people on the spot. And I started reacting that, oh, this guy is serious. Then everybody brought stickers, hit him on the head. Then he came back to the family like, what happened? What did I do? What is this?
Don't go too far. Don't go too far.
Huh?
I said don't go too far. It's a clear case of voluntary intoxication. That's
yes.
No defense. That's no defense.
Okay.
You went and take cocaine. You're liable for manslaughter. Well, you didn't intend to kill them. That's the only reprieve that you will get. But you went about killing them. You are liable for manslaughter. Yes, that's voluntary intoxication. It will not avail him a defense. Okay, so let's move over to minority. Let me see whether any of the people raising their hands have a question relating to minority. I'm coming on. Ebenezer, on mute.
Okay, thank you, sir. Good afternoon, sir.
Good afternoon.
Yes, I actually just wanted to make reference to the question that was asked by Sophia, the question on trans. Yeah, so I want to ask that, can the defense of the first limb of Section 24 of the Criminal Code actually avail the person? Because that has to do with the defense of automatism, that's an act or omission.
Please, come back.
Sorry, sir, I didn't hear you, sir.
Yes. Restate your question again.
Yes, I said that on the issue of trans and the person acting independently of the exercise of his will, that can the person rely on the first limb of Section 24 of the Criminal Code as a defense, which actually relates to automatism. You know, automatism is actually different from insanity in this case, and automatism can actually be as a result of maybe some like some cerebral impairment or natural impairments, like maybe epilepsy, somnambulism, and others. So I think that trans should fall among those categories to maybe avail.
I'm not sure whether trans will fall in that category, because I'm not sure whether trans will fall in that category. I mean, how do we know that he's in a trance? Just because he says he's in a trance, you know? I mean, when you have done something that has resulted in harm to others, the law will be very slow to afford you a means of escape. your means of escape will be closely interrogated. You know, the cases of automatism are fairly well defined. I'm not quite sure that trans will come in. I'm not quite sure about that. Okay, Ayomide Odubanjo.
Good afternoon, sir. Thank you very much, sir. My question regarding minority is if the parents of the minor would be vicariously liable for the actions of their child. Okay, so then I'll like to give an instance. So
hold on. I know where you're going.
Okay.
There's no vicarious liability in criminal law. Generally, the criminal law does not impose vicarious liability. And the parents of the minor will not be responsible for the offense committed by the minor. Unless, of course, if you can show that they instigated the commission of the offense. If they instigated the commission of the offense or procured him to commit the offense, he may not be liable as a minor, but they will be liable if there is evidence that they procured him to commit the offense. Yes, go on.
Thank you very much, sir. That's all.
All right. Adekunle. Unmute. Yes, go ahead. You have unmuted. We cannot hear you. Okay, why you are trying to sort yourself out? Karim Lawal, unmute.
Protest. So I want to ask, considering the supremacy of the Constitution and the fact that by virtue of Section 251 thereof, it's only the Federal High Court that has jurisdiction to try matters bordering on tracing. So how do you resolve the seeming contradiction of some people saying one side that the children should have been taken through the child justice system and another
No.
They should have gone to the Federal High Court?
Well, now, ordinarily, when children are involved in offenses, you don't charge them in an adult court. The family court system in every state, including the FCT that has child rights, in FCT is Child Rights Act that applies. The law provides for establishing a high court and establishing a family court, both at the high court and magistrate court level. So it is this court established pursuant to the Child Rights Act that the children should have been charged to. That's where they should have been charged to. All right. Although that's not, I just chose to answer you because that's not directly related to what we are looking at. Ridwan, unmute.
Ridwan. Sir, good afternoon, sir. Good afternoon, sir. Good afternoon, sir.
Yeah, how are you doing?
I'm fine, sir. So, sir, in a case where a child, like, let's say 7 years old or let's say 11 years old, let's just say either of those ages, sir, like now they commit murder, like you are talking to the child now, then you don't know, in a case where something like, let's say, a spirit or like possess the child, then the child now
shall
like
commit murder,
yes, stab the mother or something. So what will be the judgment for that case in such
now,
a scenario?
it depends on, you said a child, you didn't mention the age.
Let's say 7 years old.
Under the criminal code, a child under the age of 7 is not liable for anything. Under the age of 12, between 7 and 12, a child can be liable for an offense if the prosecution can lead evidence to show that he knew that he ought not to do the act or make the age. Okay? While generally after the age of 12 years, a child can be fully responsible for an offense. But up to the age of 18, you don't charge a person under the age of 18 must be subjected to the child justice system. You don't charge them in another court. So I think That is the general framework that will govern whether the child in this instance will be responsible. But the position has changed in Lagos. In Lagos now, there's no distinction between under 7 and between 7 and 12 again. There's a blanket cutoff age of 10 years. Anybody who is below the age of 10 years who commits an offense is not liable. But once you are above the age of 10 years, then you can be liable for an offense. But even then, you can only be charged in the adult court. Kehinde Ogoluwa, on mute. On mute.
Yeah. Good afternoon, sir.
How are you doing?
Fine, thank you, sir. So my question is on those with insanity issues. So there are people that have extreme anger issues that when they start their tantrums, they can't be easily pacified or controlled. So when they commit a crime for that period, are they liable?
They're liable.
I hear you, sir.
I said anger is not the same thing as mental disease or natural mental infirmity. Although we generally, in general language, we say anger is temporary madness, but that madness is not the madness of mental disease or natural mental infirmity. So when his eye clears, he will face responsibility for it. Okay, except of course, if the circumstance is such that there was a provocative act, and then he may be able to rely on the plea of provocation, except for that. But anger is not a defense of criminal liability. Koinsola, on mute.
Oh, thank you, sir. Can you hear me, sir?
Yeah, raise your voice a little bit.
Oh, all right, sir. Sorry, my question is still on insanity. I've been using up my answer, sir. So basically, I know you've clarified that act done during lucid moment, person is to be liable. So what happens when someone did it, maybe someone committed an offense and was sane at that moment? By the time of the trial, is currently insane. Would they still go with the trial? Like maybe convicting
yeah.
and
Thank you. That's not a question of substantive. This class is substantive criminal law, but I will answer it. There are rules in our rules of criminal procedure. If somebody is insane at the time of trial, you can't try somebody who is insane now. You can't try him because the person must be able to follow. So the law allows the court to call for medical examination of such a person. And if the medical examination shows that he's insane, he's just trying to dramatic, he's just trying to do some drama, he's only pretending to be insane, then the court will order that the trial go ahead. But if the outcome of the medical examination confirms that the guy is insane and is incapable of following the proceedings, then the trial cannot go on. The trial will be adjourned pending whenever is declared to be fit to stand trial. Adewale Koinsola, I thought I've called this person before. On mute. Oh, okay. Maybe he didn't pull down his hand. Okay. David Daniela. On mute.
Yes, sir.
Oh, okay. How are you?
I'm fine, sir. So you mentioned that there is no vicarious liability in criminal law, but in your textbook, yes, in your textbook, I read about vicarious criminal liability.
I said generally. That means that in some instances, the law may impose vicarious liability. As a general principle, the law holds persons liable for their own conduct. Do you understand now?
Okay.
All right.
Yes, sir.
All right, bye-bye. Okay, we're winding up. Joy, I thought you asked a question before, right?
Thank you, sir. Yeah, so I have another question.
Okay, go ahead.
Yes,
And I
sir.
can
So,
still see Woba also his hands are raised. So quickly ask your own, only one, and then I will also
okay,
allow
sir.
Woba.
Thank you,
Go
sir.
ahead.
So, what about like in the north now that they just like carry children and then put them in like Boko Haram camps, and then they train them, to use guns and all that. So and those children, they don't know any better. So if, for example, if like they now get arrested and tried now, that under the Child's Rights Act, you can't like sentence a child to like death. So what will now be the outcome of that whole trial, sir?
Well, that's not part of this class, but generally, the Child Rights Act and Child Rights laws provides for how to deal with children in conflict of the law. Of course, you can't sentence a person under the age of 18 years to death. You cannot. You cannot. So they'll be detained. Maybe the court will detain them for a number of years or subject to other provisions of the law, but they can't be sentenced to death. Okay?
But sir, can't they like put them in rehabilitation?
Well, the court will make the appropriate order. That will also be part of it. Okay. All right. Woba.
Yeah, good afternoon.
Yes. Yes, go ahead. You have another question. Final question.
Yes, sir. So, yeah, with respect to the minority. So,
speak louder. I can hardly hear you.
Okay. Can you hear me, sir?
Yeah, it's better now.
Okay, yeah. So my question is on minority. So one, not sure how we can balance the need to hold minors accountable for most of their actions, which they actually carried out in the capacity of adults. Because I've witnessed, several times whereby certain minors, carried out acts or even or mission that that adults ordinarily can cover. I want to know how we can balance the need to hold them accountable for their actions and also with the need to protect and rehabilitate them in the same time. And then,
well, that is the responsibility of the court. The court will look at the circumstances of the case and see and make a determination of how best to deal with the child. The upbringing of the child, usually plays an important role in how a child will turn out, in adulthood. So if it is a child that has been deprived, subjected, grew up in a poverty and deprived environment, and that child, because of that, is stealing, you can see that it's not as if the child wants to be stealing ordinarily. That stealing maybe is induced by poverty and things like that, and maybe his parents don't have any visible means of livelihood. So such children, instead of sending them to jail, you can, send them to a vocational training, where they can learn a trade and then be able to earn employment and earn income for themselves and so on and so forth. So, but if the child's offense is very serious, like in the US, they have a system in the US where if a child commits a very serious offense, and depending on the age of the child and how young the child is at that time, there are provisions in their law that allow that child to be charged and treated as an adult. Although, a lot of people don't agree with that because their system can sometimes be very harsh. The child will be charged as an adult and treated as an adult and punished, as an adult. Even though they may not sentence the child to death, they may sentence the child to life imprisonment. So I think their own approach, but usually it is when the child has committed a very serious crime. Maybe he has killed somebody or he has killed another child. Those are very serious matters. You have to balance, just like you have said, the needs of protecting the society with the need of, also looking out for the welfare of the child who has been found to be, in conflict with the law. So I think those are the factors that are important. So if there are still any other questions, I think we'll take them in next class. So I will send the lectures that I expect you to listen to the next class ahead. So that will be it. So if you have not indicated your matric number, please do so now. And for those who are watching live on YouTube, they should also indicate their names and matric number on the YouTube channel. I will harvest the two and match them together. All right. Thank you very much. Enjoy the rest of your day. God bless you. So we'll leave it on for about 2 or 3 minutes for everybody to put in their everybody to put their matric number again.